wow. Friday, the Supreme Court, many of you know the Supreme Court hears cases all year, and then in June, though they'll do some at other times, but in June, they announce all their decisions. They announced 6 decisions yesterday. We won 5 of the 6, and the 6th one, they deferred it back to the court, so we didn't lose that one. I'm just going to go through these. I will link to articles so that you can read it in more depth and share it. I'll hit the highlights because it's unbelievable. But it starts with the mother of all decisions that we needed really badly. And Jonathan Turley predicted earlier this week this would happen. Supreme Court ends abuse of injunctions. No more judicial supremacy. What does this mean? This means that the Supreme Court ruled 6-3 on Friday in the controversial Birthright citizen case that lower courts cannot simply issue nationwide injunctions, and that doing so is an abuse of their judicial power. Game, set, match on the lawfare. And it gets better. The decision in Trump versus Casa vindicated the Department of Justice strategy. Pam Bondi and her lawyers, outstanding, kudos to them, of arguing against the idea of nationwide injunctions rather than addressing the underlying substantive issue in the case, namely dispute over whether the 14th Amendment to the Constitution guarantees citizenship upon birth on U.S. soil. Conservatives argue that birthright citizenship is abused by illegal migrants to make their children into U.S. citizens who can later sponsor the legal immigration of the rest of their families. They also argue that no other nation has birthright citizenship and that the 14th Amendment did not intend to create it. However, even though this case was about courts saying Trump's executive order ending birthright citizenship is illegal, that wasn't what the DOJ argued. They argued that those courts don't have the right to issue a national injunction and stop Trump. And the Supreme Court agreed. Given a number of contrary rulings in lower courts, which slapped nationwide injunctions on President Trump's executive orders on the subject, the DOJ kept the focus of its challenge to the narrow issue of nationwide injunctions. Democrats, and to a lesser extent Republicans, have sued in friendly jurisdictions in recent years as a way of stopping administrative policies that they do not have the legislative votes to overturn. So that is judicial radicalism, judicial interference with the executive branch. And so Amy Coney Bryant, of all people who we've been really disturbed with in some of her decisions, I don't know what got into her, but folks, listen to this. Listen to what she wrote in the majority decision in this case. It was an unbelievable smackdown of DEI Supreme Court Justice Ketanji Jackson, okay? The Supreme Court Friday ruling narrowed the scope of judicial injunctions, also including a scathing rebuke of Associate Justice Ketanji Brown Jackson, asserting she sought an imperial judiciary and that her views run afoul of more than 200 years of precedent. This is what Amy Coney Bryant wrote. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary, wrote Associate Justice Amy Coney Barrett. I think I said Bryant, didn't it? It's Barrett. Amy Coney Barrett. Justice Jackson would do well to heed her own admonition. Everyone from the president on down is bound by the law. That goes for judges too, she added. Justice Jackson, Barrett further criticized Jackson for ignoring relevant statutes because they came boring legalese. The justice found that Congress had not given lower court judges the authority to impose nationwide injunctions and that they were unnecessary for the courts to provide relief of plaintiff parties. While the ruling was a clear win for the Trump administration, Barrett's choice words for Jackson appeared to signal a growing frustration between conservative justice and their new colleagues who are just radical leftists who have no understanding of the law whatsoever. If we can ever get 60 senators in the House, U.S. Senate, we need to impeach Brown. She should have never been on the court. She's an embarrassment. She's an embarrassment. I mean that. And no, I'm not a racist. And she's not an embarrassment because she's black. She's an embarrassment because she doesn't know what the hell she's doing. She's an idiot. She shouldn't be on the Supreme Court. Thank goodness that Trump was able to appoint enough judges to discount the insanity of the radical left judges and protect our nation from their insanity. That's why, Obama and Biden and all those guys want to stack the Supreme Court and all that, because they can't win. They're anti-constitutionalists. And so they just ignore the Constitution until we slap them down. And baby, we slapped them down in that case, and let's just keep going on. Earlier in the week, which kind of set the stage for that ruling, SCOTUS ruled 6-3 that Trump can deport illegals to third countries. Okay? The Supreme Court issued a big win for Donald Trump administration, ruling pauses on as orders from a lower court judge that required the administration to give illegal immigrants a warning before sending them to other countries with which they are now prioritized. The program called Third Country Removal was shot down by a federal judge in May. U.S. Judge Brian Murphy blocked the administration's attempt to deport a group of immigrants to South Sudan. Okay? Shocker, he was a Biden appointee. So the Supreme Court ruled 6-3, again, the three Dems voted against it, that Trump can deport people to third countries. And then that is what set up this idea that you can't put in a national injunction to stop the executive branch for doing what the Constitution legally gives them the right to do. And then it just kept coming on Friday. SCOTUS rules in favor of parents seeking to opt children out of reading LGBTQ-themed books. This was huge, and this is just common sense. And as Trump said, when he ran, he said, I will restore parents' rights. I will protect your rights to decide what your children are taught and what they learn. And remember, the teachers union said, you don't decide that. We're the union teachers union. We decide what your kids learn. Yeah? No. Didn't happen, kids. You lose. You lose. The U.S. Supreme Court in a 6-3 decision ruled in favor of parents seeking to opt their children out of public school instruction that conflicts with sincerely held religious beliefs. The case, brought by a group of Christian, Muslim, and Jewish parents from Montgomery County, Maryland, sought a guaranteed exemption from the classroom reading of storybooks with LGBTQ themes, including same-sex marriage and exploration of gender identity. Justice Sam Alito, writing for the court, said the decision that refusing to allow parents to opt out their kids from instruction that poses a very real threat of undermining their religious beliefs and practices violates the First Amendment protections for religious exercise. The Montgomery County Board of Elections introduction of the LGBTQ inclusive storybooks, along with its decision to withhold opt-outs, and they were saying, you can't say my kid's not going to this class where you're going to teach this, placed an unconstitutional burden on the parents' rights to the free exercise of their religion. The court found that the parents are also likely to succeed in their lawsuit over free exercise claims and have shown they are entitled to a preliminary injunction while their lawsuit proceeds. So, bang, you get to decide. The parents allege the use of the books in an elementary school curriculum without an opportunity to be excused amounts to government-led indoctrination about sensitive matters of sexuality. The school board insisted the books merely expose kids to diverse viewpoints and ideas. No, it wasn't. It was the communist-sponsored, go to WeThePeopleConvention.org, search on China billionaire funds trans movement in the U.S. China funded the trans movement to destroy American families, schools, and communities. Look it up. That's a fact. And what they did, what the commies in the Biden administration did, was force it into schools to destroy your family, because that's the goal, to destroy the United States. That's why we are fighting so hard to preserve it. The Supreme Court just said, you can't do it. Don't let them do it in your school. If anything like that's going on, you now have a case to sue and win from the Supreme Court. Keeps going, keeps going. Key takeaway from Supreme Court decision on Planned Parenthood funding. A case known as Medina versus Planned Parenthood focused on South Carolina's attempt to prevent Medicaid dollars from flowing to Planned Parenthood. The states have more leeway to fund Planned Parenthood, now the nation's largest abortion provider, after a major decision from the Supreme Court. Planned Parenthood, sued, saying that South Carolina, because remember, Medicaid, is partly from the federal government, but the states actually manage it. And South Carolina said, no Medicaid money can go to Planned Parenthood. That's not health care, that's abortion. And they sued, okay? Well, now, because of this decision, every red state is going to do this. And Planned Parenthood knows. They are on the ropes, folks. Planned Parenthood said after the decision that this is literally terminal to their organization. And Donald Trump has said he's going to get rid of these people because they don't provide health care. That's a lie. They abort babies for a living, and mostly black children, mostly blacks. This is just eugenics under a different name. The Supreme Court just said, we the people can say, we're ending this. We're ending this. Awesome. And then one final ruling, Supreme Court upholds Texas age verification porn law. And for many of you watching this podcast, this is controversial. You know this is really important to me because I've been fighting for age verification for social media because it's killing, literally killing our children. It's destroying their minds, their mental health. It's a fact. Look it up at wethepeopleconvention.org. Hit the little search icon and look up Jonathan Haidt, H-A-I-D-T, okay? And you'll see his video. You'll see all the laws they're proposing. And the fight is, well, if you verify on social media that you're over age 16, then I'm losing my First Amendment rights. I disagree. I bring up the case of, you can't buy a gun. You can't buy drugs. You can't buy cigarettes. You can't buy alcohol if you're a child. You got to show your driver's license. So why shouldn't you have to do that online? This ruling cracks the line of defense. The Supreme Court on Friday upheld a Texas law that requires pornography websites to verify age of users before they can access explicit material. The 6-3 ruling, Free Speech Coalition, Inc. versus Paxton, that states may require age verification laws to access sexually explicit materials in order to prevent children from accessing those materials. Of course, the three Democrats, basically, fought it. Justice Clarence Thomas wrote the deciding opinion. The Texas law at the center of the case requires pornography sites to verify the age of users before providing access and applies to any website whose content is 1/3 or more harmful to minors. Petitioners, Speech Coalition, Inc., representatives of the pornography industry, sued Texas Attorney General Ken Paxton to prevent enforcement of the law because it burdens adult visitors of the sites who have First Amendment rights to access the materials the website pushes. You have a First Amendment right to access it. That doesn't mean you have a right to not have to prove your age, just like you have a right to access alcohol or cigarettes or guns. You have that right. The Second Amendment gives you the right to buy a gun. But that doesn't mean we can't protect minors from having guns. And so you got to show your driver's license. Don't understand what's so controversial here. Don't get it. Some of you will disagree. Write to me at info@wethepeopleconvention.org and state your case. This is big. Even though it's not about children social media verification, the fact that this cleared the courts is going to help us get that done. And ladies and gentlemen, that will be a great day when we protect our children from using social media, TikTok and Instagram and even Facebook, though they don't do that much, because the evidence is totally clear. It is making our children into mentally ill zombies. That's why they can't do a job at work. It undermines their self-confidence, their ability to think for themselves. The evidence is crystal clear. Go look it up. We've got to protect our children, and you're having to identify yourself to access social media or a porn site is not an infringement on your First Amendment rights. It's common sense. So I was really excited about this.